Okay, this is what I tell everybody what to do. The first thing you do is write a letter, a cease and desist letter. Tell them you give them notice, you're interfering with right, blah, 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 blah. The right to association, the right to congregate, the right to carry a gun, the right to religious practice, right to whatever. The right to pick my nose and scratch my butt and be left alone while I'm doing it. Anything. You're interfering with my right to blank. You give a notice. You say, look, if you don't stop interfering with this right, or you stop interfering with giving me the right to go before a jury, you stop interfering with my right to have a common law proceeding. If you don't stop doing this, I'm going to charge you a fee. I'm going to charge you $1,000 a day until you stop interfering with this right. Not only do I believe I have this right, but the Constitution supports this right. Alabama Constitution and New Jersey Constitution supports this right. State Code supports this right. State Supreme Court of New Jersey also believes that I have this right. So it's not only my belief. You know what? I'm going to come in with some good foundational evidence, backgrounds, proofs, and facts that my claim is standing on good foundation based on your freaking written law. So not only is it my belief, it's your belief. So that you can't anyone notice. You want to put all these citations in? That's where you do it. But you don't say, well, Alabama says I could do this in New Jersey. New Jersey doesn't say nothing. Tomorrow they're going to change the state to something else. They're pulling away from the United States. They're going to change it to whatever they want to change it to, Asbury Parkland, whatever they want to change it to. So you just use their old stuff.
Who's this letter to? The plaintiff?
The judge. The judge who's saying denying you the right to a jury trial. Who's ever doing you the wrong? Who's ever the wrongdoer? You say, hey, that's wrong. You can't do that to me. Stop that. That's the letter you give him. Hey, that's wrong. Don't do that to me. Stop that. Not only is that my belief, but the Constitution says this, the statutory code says this, the Supreme Court says this, the Bible says this, Ralph DeCabbage says this, McGill Gorilla says this. Everybody says this. You can't do me this way that you're doing me. Stop. If you don't stop, I'm going to charge you $1,000 a day. And I'm going to bring you before a jury. And if the jury finds that my belief is a good belief, they're going to give me the thumbs up like American Idol and go like, hey, we like your show and dance you just put on for us. You know what? Not only are we going to give you $1,000 a day, hell, we'll triple the damages. Yeah, that judge shouldn't have done that to you. Pay that nice lady, judge. That's how you do your notice. You notice a cease and desist. And then when they reach a cease and desist, if they just blow you off, you can say by tacit acquiescence, you can put that in a notice too. If you don't respond to this in 72 hours or 14 days or 21 days or 6 months, I'm going to say that you tacitly acquiesce to all the terms and conditions of this notice. And that you can do that. And then, like I said, if they still continuing to do this, say, well, I'm sorry that we couldn't settle this matter on a private side, but it looks like you've given me no choice, but I'm going to have to evoke my 9th Article and 7th Amendment Article rights under the Bill of Rights to invoke a common law jury trial against you.
How do you say that? In another letter?
Yep, just another letter. Let 3 days go by, 14 days go by, 21 days go by, 6 months, however long you wanted to let them go by. You could claim a wrongful act that somebody did to you 100 years ago. There is no statutory limitation. There is no latches that may be imputed to the public. If you bring up a statutory limitation and you're the prosecutor, then they could bring it up as a form of defense. Don't ever say 6 years went by, 2 years went by, 80 years went by. Don't ever bring up any of that nonsense. And if you drop dead and die, the Judicial Act of 1793, Section 31 says that your descendants could pick up your claim if you drop dead and die. Your children's children's children could pick up your claim because man can't be latched. The attorneys can. The Constitution latches the states to the federal government. They're all latched. They all took contracts. The judge took an oath of office. An oath of office is they bound themselves to the Constitution, or they bound themselves to certain duties and responsibilities. They bound themselves. They latched themselves. They have a contract to perform under. You don't. You can do whatever you want. You're unlimited. Your capacity to move and perform and do whatever you want is unlimited by any latches because you're a man. You're free to think. You're not a Frankenstein. You're not a creation of the state. You're not a monster. It's very simple. Believe me, when they see it, like I said, I checked with the clerk of the court's office in Alabama today to see if my case had a PACER number so you folks could watch along and watch this extremely simple claim go through the federal district court.